Just this Wednesday, the Supreme Court ruled that the federal employment discrimination laws do not apply to teachers at church-run schools whose duties include religious instruction. So today I will share the cases, the decision, the history, and the impact of this decision. Yesterday, on July the 8th, 2020, Supreme Court ruled the Constitution's protection for religious liberty exempts church schools from federal anti-discrimination laws. Two teachers sued Catholic elementary schools in Los Angeles County for discrimination because they believed they were fired unjustly, one due to the disability and one due to the age. The judge's decision favored the Catholic schools, arguing that governments may not interfere with the employment decisions since the schools are part of a church's religious mission. So today I will specifically talk about the two cases that leads to this decision, as well as one of the previous case in 2012, which the interpretation of these two cases basically extended from that case. So the first case, Kristen Biel, she was a fifth grade teacher at St. James School. Her teaching contract was canceled after she told the principal that she was diagnosed with breast cancer. So she then sued the school under the Americans with Disability Act, the ADA, which this act protects employees from discrimination based on a disease such as cancer. Unfortunately, she passed away last year, but her husband, Darryl Biel, maintained the suit. The second case is Our Lady of Guadalupe School versus Morrissey-Berru. Morrissey-Berru, she was a fifth grade teacher at Our Lady of Guadalupe in Hermosa Beach for decades. And the principal suggested she might want to retire. She refused, and her teaching contract was not renewed. So she then sued under the Age Discrimination in Employment Act, alleging the age discrimination. So the argument of the decision of these two cases is that the First Amendment protects the rights of religious institutions to decide for themselves, free from state interference. And the court saw these cases as that the religious schools, they are making their internal management decisions that are essential to the institution's religious mission. Even though the lower courts have long been considered the ministers are exempt from the nation's employment law, however, the teachers are treated differently. So a main argument in this case is that whether the ministerial exemption should be extended to teachers from ministers. So then we have to look at another case, which in 2012, the Supreme Court ruled unanimously that a fourth grade teacher at a Lutheran school who was commissioned as a minister could not sue over her firing because she has this minister's position and she was exempt. The issue in the pair of cases from Southern California is that whether this exemption should be extended more broadly to the teachers in the church-run school whose primary duty was not necessarily religious instruction. And what does it mean for the decision of these cases? So as I mentioned, the exception for the minister's position was expanded to the teachers, which means teachers cannot sue the school based on any type of discrimination, not only for religious, but also for age, gender, disability, etc., all the protected traits. And there are nearly 200,000 teachers at the religious schools, and they will all be impacted. And not only saying this teacher's position, in the future, what about the school coaches? What about the nurses that works at the church-run schools? What about the social workers, the in-house lawyers? Are they going to be covered under this group of people that's exempt from anti-discrimination law as well? So if they are, then all of these employees cannot sue for discrimination for any reason, even the reasons that's completely irrelevant to their employer's religious tenets. And remember last month that there was a victory. We just got a victory for the LGBTQ group from a Supreme Court ruling that gender identity and sexual orientation should be protected under discrimination law. And now this protection was being interpreted narrowly, again, because the exemption of religious affiliated employers. What do you think about the ruling of these cases? Leave your comments below. Thank you.